Very good morning, my dear students. So, all of you seem to be exciting about today's session about the subject corporate and other laws. So, let's see the excitement, right? Let's quickly revise what we have discussed in our previous session or sessions, isn't it? Yes, sir, definitely. So, let's first recall the list of chapters, isn't it? Let's recall the list of chapters. By the way, how many chapters are there in Companies Act 2013? 1 to 29. And how many schedules? 1 to 7. So, chapter number 1, preliminary. Chapter number 2, incorporation plus incidental matters. Next, chapter number 3, prospectus and allotment of securities. Chapter number 4, share capital and debentures. Chapter number 5, acceptance of deposits. So, deposits in short. Charges is 6, right? Security. 7, management and administration, which includes even general meetings. 8 is dividend. 9 is accounts. Very good. 10, audit and auditors. 11, directors appointment and qualification. 12 is also relating to directors, but meetings, powers and restrictions. How about 13, managerial person and remuneration of managerial person. So, appointment plus remuneration. Okay. 14, inspection, inquiry, investigation. What happened? Shivani, come on. 15, compromise arrangement, amalgamation and reconstruction. 16, prevention of oppression and mismanagement. 17, registered valuers, valuation, registered valuers. 18, defunct companies. Good. 19, sick companies, which is repealed, which is omitted from company law. 20, winding up. 21, unregistered companies. 22, 21A, producer companies. 22, companies incorporated outside India. 23, government companies. 24, registration office and fee. 25, company to furnish information and statistics. I expect now you to recall this. 26, Nidhi companies. 27, NCLT and NCLAT. 28, 29, miscellaneous. Then schedule number 1. I have told you how should you answer. Table A to E is MOA. Table F to J is AOA. Isn't it? Then next. Schedule number 2, depreciation. Schedule number 3, schedule number 4, schedule number 5. पूरा देख के बोल दो. Schedule number 6, infrastructure activities. Schedule number 7, CSR, right? Corporate social responsibility. Good. So this is how we have got 7 schedules. So how many chapters are relevant for us? 1 to 10 plus 22, and then anyways miscellaneous indirectly applies or some other provision from some other chapters may come, but 1 to 10 plus 22 is what is there as specified by ICAI. Same way, if I talk about schedule numbers according to those chapters, then it is schedule number 1, schedule number 6, schedule number 7, which are applicable for this paper called as corporate and other laws, CA, inter of course paper number 2. Correct? Yes, sir. Just a minute before we continue. Okay, so if you recall even the different tables, table A, for which company we have model articles there? Model articles or model MOA? MOA. For which company? Company limited by shares. Whereas table number B, MOA, but then company limited by guarantee, but without share capital, and then with share capital is table C. Table D is unlimited guaranteed company without share capital, and E is with share capital, isn't it? Next, table F, model articles, yes or no, for company limited by shares. And then table G, yes. And then table H, correct. And then table I, unlimited guaranteed company without, with sir, then without. So in case of articles, if you remember, we said it's with first and then without for this table number G to table number J. Correct? No? Yes, sir. Fantastic. So let's talk about doctrine then. If you remember, what's the meaning of doctrine? We said legal principle which has got universal acceptability, though it may not be a law. So it's not necessary that doctrine should be law. Correct? No? So different types of doctrines in company law we have talked about. To be very precise, 3. Doctrine of constructive notice. What is it? Doctrine of constructive notice. Any outsider, any stranger dealing with the company has to read MOA and AOA and then verify. And then verify whatever is written has been followed. He has to ensure, the stranger has to ensure. So that means this doctrine is giving protection to whom? Company. So that's where we said practically this is not possible. And then doctrine of indoor management. The stranger can, come on, you're behaving as if I'm telling you for the first time. See, foundation of also you have read. So ensure or assume, presume that whatever is written has been followed by the company. That's what we say in doctrine of indoor management. So this doctrine gives protection to whom? Outsider. So this is more practical. Then doctrine of ultra virus, when we say, that means doctrine of ultra virus. Doctrine of ultra virus the company. Doctrine of ultra virus means doctrine of ultra virus the MOA. Same way ultra virus the object clause. So all these 4 are one and the same, right? Ultra virus the company, ultra virus the MOA, ultra virus the object clause. Can it be ratified? No, even by the whole body of shareholders it can't be ratified. Whereas something which is ultra virus the articles can be ratified by passing special resolution in general meeting. Same way if I talk about ultra virus the directors, it can be ratified by passing ordinary resolution in general meeting, of course, isn't it? Next, few other fundamentals also we talked about, like company form in a nutshell. So we said there are shareholders who put in money. There are shareholders who put in money. Then board of directors who will manage the company, correct? And then auditor who's going to come and verify, who's going to come and check whether everything has been followed properly or not and give his report, isn't it? So that way we said in a nutshell, it's not the same person who's putting in money is going to manage the business. Yes or no? But there is a possibility that shareholders also may become directors. No one is stopping them, no prohibition there as such, isn't it? If he's capable enough, he can manage, then why not? But is it a rule that if a person has to be a director, then he has to be a shareholder? No. Auditor has to be independent person. You remember, no? Independent audit we want. That's where we said a shareholder, a director, can they become auditor of the same company? No. Good. Then we talked about 2-tier management structure, which also is called as what? Oligarchic management. So what does that mean? Generally, we know board of directors manages the company. However, come on, answer. Exceptionally, even members also may be involved in decision making, or members alone may take the decisions. That will happen only in non-routine matters. Routine matters it is. Come on, answer guys. Board of directors. Didn't we discuss this? We have. I've given you examples also, but now because it's revision, obviously I can't discuss everything what we have discussed, but at least a few things we are trying to recall. Then appellate structure under company law, meaning if someone wants to appeal, someone is unhappy with something in the company matters, then NCLT. What is the full form of it? National Company Law Tribunal. In short, we can also say tribunal if we want. And then NCLAT is the next authority. National Company Law Appellate Tribunal. So if we want, in short, we can also say appellate tribunal. And then the apex authority is Supreme Court. And in some cases, there can be also a special court. Special court is a quasi-judicial body. I've told you that's not a judicial body. Then, generally appellate structure includes Court of Judicial Magistrate of First Class, that is JMFC, or Presidency Magistrate of First Class, that is PMFC, or come on, yeah, Metropolitan Magistrate of First Class. So this is the first one we said, right? Or this is the lower one we said, and above this, district court, city courts, or session courts, and above that we have got High Court, and the supreme authority, the apex court, is Supreme Court. This is the general appellate structure, right? Company law, NCLT, NCLAT, and Supreme Court. This is the general one. Are we going to use this? No, sir, but rarely we may come across. That's where we have covered these levels. We have not covered every level, I've told you. Now, having talked about appellate structure, so we also discussed administrative structure as far as company law is concerned. So, when we talk about administrative structure under Companies Act, we've got Ministry of Corporate Affairs. There is nothing but the government, right? Central government. So, but central government has got respective ministries, specific ministries. And then we've got regional directors. How many regional directors are there in India? 7. Yeah, good. North, West, South, East, and then Southeast, Northwest, Northeast. Isn't it this way? We've got 7 regional directors. Then we also have got Registrar of Companies, which we in short call it as ROC. Right? ROC. So general rule with respect to ROC is one state, one ROC. However, we may find some exceptional cases as well, like 7 sister states in the east. 7 sister states in the east. That means 7 states, but only one ROC. Whereas Maharashtra and Tamil Nadu, though one state, but have got two ROCs. Maharashtra has got ROC Mumbai, ROC Pune, and Tamil Nadu has got ROC Chennai and ROC Coimbatore. ऐसा गड़बड़ नहीं. Tamil Nadu has got, जिसमें महाराष्ट्र बोला, so you have to first specify Tamil Nadu, correct? So that is how there can be some exception as well. Even CRC is an exception because for few matters they have this centralized registrar of companies. Centralized, when we say all over India, it's one, correct? Like reservation of name, one example I've given you where CRC comes in, correct? Yes or no? Right? Shown you the picture as well, directly taken from the MCA's website. Then adjudication, what is it? It's a process. That means it's not just one single activity. It's a series of activities, isn't it? And what are those? That once a complaint is received, inquiry should be held, some proceeding, some trial, and then only the order should come. It's not that complaint received, order given. Is it like that? Complaint received, order given? No. In between what happens? Some inquiry, trial, proceedings happens or not? And that should be fair. That should be fair. Next, who can be the adjudicating authority? Come on, who has to be adjudicating authority? Just courts? No, sir. It can be judicial, quasi-judicial bodies, or even CG or authority appointed officers. Can you give me one example relating to authority appointed officers? Yes, sir. SEBI. I've told you SEBI may appoint some officers as far as these financial markets, capital markets are concerned. Isn't it? So those officers also can play the role of adjudicating authority, adjudging, adjudicating, judging, isn't it? Then what are the factors the adjudicating authority will consider before imposing penalty? Come on, will they consider factors before imposing penalty? Yes, sir. So what are those factors? Nature of default. Very good. Repetition of default, that is how many times it has been done. Only first time it is done, probability, penalty may be lesser. But if it is done 4th time, 5th time, then so more the number of times the offence is repeated, what will happen is penalty is going to be more. We have already seen section number 451, if you remember, that is talking about if same offence is repeated within 3 years, then fine will get doubled. That's how it is. Then size of the company, nature of offence, whether it is injury to public interest. Suppose it is injuring public interest, it is harming public interest. Penalty will be more or less? More. If public is getting injured, that means penalty has to be more and more. Acha, I have even helped you understand what is public interest. You remember, no? Public means what? All the chartered accountants of Hyderabad is public. Huh? No. All the doctors of Hyderabad are public? No, sir. Every section of public has to be there. Then only we say public. Like I have told you, creditors, shareholders, board of directors, employees, suppliers, like that. If you talk about all, that is public. Or if not all, yeah, should be involved. No, some groups should be involved or not. Only shareholders getting affected. Do we say public getting affected? No. Correct. Then, intention of the person who has committed the violation or offense also matters. If he has done intentionally, will the punishment penalty be more or less? More. If he has done it unintentionally, then lesser. So like that, there are few factors which we talked about. Few. Why I am saying few? There can be more factors as well. That's where I've written etc. as well, and I have told you this is an inclusive list. This is not exhaustive list. Different types of penalty we talked about. So monetary, non-monetary, isn't it? And more important is sequence. So how will you look out for penalty? Specific section we will see. But if you don't find specific section, okay, covering the penalty, then is it like no penalty? No, still penalty is there. But only thing is, we'll have to see other sections, nearby sections. There also you don't find then general penalty clause for the chapter. There also not there, or that is not there because every chapter may not have general penalty clause. Then we go to general penalty clause of the act. And as far as company law is concerned, which is that section? 450. 450 is the general penalty clause for the whole of the act. And we have discussed that as well. Yes or no? 450 did we discuss or not? Yes, sir. So company and every officer in default or any other person who has contravened, who has done the violation, who has done the default, will be punished with how much fine? Up to rupees 10,000 plus up to rupees 1,000 per day, during which the default continues, subject to a maximum fine of how much? 2 lakhs as far as company is concerned, and other persons which we are talking about is 50,000. But if the same offense is repeated within 3 years, then they say double the fine. Correct? Double the fine. Same. It is not similar offense. How about imprisonment? That they did not say double. So that means it remains the same. Then what about section 447? Is it a general penalty? No, sir. It is penalty for fraud. So if it is not a general penalty for fraud, what do we understand? Specifically, it has to be mentioned that section 447 penalty will be applicable. Then only 447 is applicable. Otherwise not. This we didn't discuss. We said we'll discuss it later. Yes or no? As of now, did we discuss any practical question? No, sir. We have covered the basics of company law and some not completed actually. We have started with basics of company law and we have seen some overview of company law. We'll still continue with what? Basics. Yes or no? First chapter is what for you? Chapter number 1, basics. Section number 1 we have seen, but section number 2, definitions is yet to be seen or not? So that is still there. So still few fundamentals will go on. It's not that it is completed as such. Okay. Acha, what else did I show you? What else did I show you? Official gazette. I have shown you the Bare Act. Basically, what I have shown you is Bare Act of the Companies Act 2013. Isn't it? So, if you just recall, 2 clause 1 to 2 clause 95 is what we have when it comes to section number 2. Correct? So, 2 clause 1 to 2 clause 95. We have got definitions. Section 2 comprises of what? Definitions. Then, if you just observe, what is there next? Chapter number 2. In chapter number 2, bolna bhai, what is the heading of chapter 2? Incorporation of company and matters incidental thereto. That's what we said while discussing the list of chapters. What is chapter 2? Incorporation of company and matters incidental thereto. That is the heading of the chapter. Then we have got section number 3. Just observe, I have highlighted in yellow. Section number 3. 3. Are they writing section 3? No, they're just putting number 3. We need to understand that it is what? 3. Right? Section 3. And where is the title of section 3? On the right hand side. I've told you, look for the marginal notes. Margins you will find. Yes or no? You forgot? Yes, sir. Formation of company. Right? Formation of company is what is written there. That is title of the section. Which section? Of course, now we are talking about 3. So 3. Beside 3, there is number 1 written in brackets. What does that mean? Subsection. And then below that, what do we have? A, B, C. What is this? Clauses. I have told you what is a clause. I hope you remember. Suppose, let us say, okay, after 3, beside 3, there is no number 1 and no sentence there. Directly it is A. Directly it is B. Then what will happen? I said there's no line, nothing there. Okay, directly there is A. Subsection then again. No sir, ABC, no sir. अरे कुछ भी line नहीं लिखा, कुछ नहीं लिखा, तो उसका मतलब क्या होता? That's what happened. No, here number 1 directly they've given number 1 instead of 1. I'm saying number A. So it means subsection only then. But suppose they don't write number 1. Let's imagine for a minute that there is no number 1. Okay. Come on guys, tell me yes or no at least. Let's say this is not there. So 3 and then beside that is a sentence and then comes A, B, C. So what does it mean? 3 clause A, 3 clause B. That means, sir, there might be subsection and then clause, or maybe there is no subsection, still there is clause. I have told you that before also. Just an example, now proving by an example here. Okay. So are you expected to remember even? Are you expected to even remember subsection numbers? Sir, what do we know, sir? Arey, use your brain and tell me. Are you required to remember section numbers? Yes, sir, we are required to. We should know the section numbers because they are expecting us to gain which knowledge? Working knowledge, no? We should try to become an expert, no, here in these chapters which we have. Maybe FEMA, what did they say? What is the objective? Basic understanding. You remember or forgot? But when it comes to company law, LLP, they have more expectations. So don't you think they would even want us to know the section numbers? So next thing which I am asking is, apart from section number, do you think you need to remember subsection numbers, clauses as well? No, that much is not required as of now. But slowly, when your level increases, like when you go to final, when you become a chartered accountant, people will start expecting even subsection number clauses as well. If not for everything, at least important provisions. समझा भाई? So don't waste your time unnecessarily by writing subsection numbers. Then I have highlighted few more words for you here. If you can recall, what is it? Provided that, what is it? I am not asking to read there. Proviso. That means exception. That means a special case. Provided that, provided further that, provided also that. Isn't it? So, sub proviso. But there is no sub proviso, only one single sub proviso. Sub proviso has got a sub proviso. That's why they had to write what? Provided also that. Isn't it? Just observe. Provided also that. Isn't it? Then what do we have here? So it's very important that we revise whatever we read. You might understand at that point of time, isn't it? But after that, you may forget. But if you revise, come on, there are chances you will remember. Is it only understanding we have to do here? Come on, guys, please answer. Is it only understanding? No, you'll have to memorize also. Why? You have to write the examination. Correct or not? Madam, it will take some time to get into the flow. Don't worry. Okay, they are already there since last 5 days. So obviously they'll be better. But you will also get to that level. You just need to spend some time. Okay. Right. So what was I saying? That only understanding will not help, but also revision is a must. Revision is a must. Revision will help you remember things. Only understanding will not help. Isn't it? Yes, sir. Absolutely. Okay. So if you just observe after section 3, you will find what section number 4 is there. Like that, there are different sections.